December 2015.
I mean, we have the OCM position.
Yes.
We know what they say because they've put up an affidavit and testifying. Mr. Molefe says, in effect, agreeing to the proposal to increase the price for coal with OCM was not in the interest of Eskom. And in any event, if OCM thought that Eskom was being harsh on them in insisting on that contractual price, the agreement had a way that would have given them relief from that harshness. That is, invoking the hardship clause, going to arbitration, and if they won the arbitration, then they would get relief. They chose not to pursue arbitration to its final end, or they did not for whatever reason, but I think he implies the fact that they didn't pursue it up to the end, that is arbitration, was not Eskom's fault, whatever reason there might be. So I'm not sure to what extent OCM responds effectively to that line of argument.
Yes.
Now, Exxaro says they wanted Eskom to acquire some land so that they would
Increase the volumes.
Yes, and they had negotiations. The negotiations didn't produce the desired result, and their contract was coming to an end. Now, it may be that there is some point, but I'm just saying I'm not sure.
Yes. Yes.
But I intervened when he was about to respond. Let me allow him to respond.
Yeah. I haven't gone into the details of it, but Mr. Molefe, you can respond, yes, in the context of them saying, don't look at the price in isolation, look at it in the context of Eskom's delay in acquiring the piece of land. Then we can move on.
My understanding was, as the contract was coming to an end with Exxaro, their price demand was 1,300. And in addition, they wanted us to buy land to give to them. That was their demand. They're demanding that we should buy land and give it to them.
As a client.
As a cost plus mind.
Yeah. Yeah, we must buy land and give it to them, which is what I was uncomfortable with, especially in the context of land redistribution and so on. Why do we buy land and give it to these guys? Now, Mr. Slick, price. There is no price unless there is a willing buyer and a willing seller. So you can't say that the price was this much if they had done this and this and that, when nobody was prepared to pay that price. The fact that somebody has demanded a price does not mean there is a price. There's no price. The price exists when there is a willing buyer, willing seller. An indication of the market price at that time for the coal that was going to anode was in fact the agreement that we had reached with the 6 small suppliers, which was in the 400, around 400. So that was, they were willing to supply us at 400, we were willing to pay 400. They were not making demands to be given land and 1,300. Why did we have to agree to their demands? Why did we have to renew that agreement? If we had renewed that agreement, when unfortunately I was ill-disposed and was not in a position to, but if we had renewed that agreement and bought them land and paid 1,300 a ton, when we could buy coal at 400 from BE suppliers, I would still be sitting here, except that this would be criminal proceedings.
No, except also that the 1,100 is not common cause.
Well, but the 600, we can take the 600. Even at 600, it's still higher than, the point that I'm making is that
Yeah,
the price was higher than
Yeah.
what we could get the coal for. So, I mean, there's 600, there's 700, there's 1,100, and I'm saying that they wanted 1,300. All of those things are not acceptable. Even if it was 500, it would not be acceptable, because you can get the coal at 400 or at 450. If you can get the coal at 450, why buy it at 500? Just because it's Exxaro. There's a man in Newcastle who asked Mr. Gdele the other day, "Nibasabane belungu?"
can we go back to the matter?
Well, yes.
If we, should
Yeah. The point is, how far do you want to take this
No,
Exxaro issue?
I want to go back to OCM, Chair.
Yeah.
Yeah. Let's go back to OCM, particularly on the point the chairperson was raising, that the hardship clause was not pursued because we know, you will recall the meeting of the 3rd of September, as the parties again agreeing to supply. The parties again agreed to supply. So after the termination, which is in June, there's a resuscitation of the hardship arbitration. But in September, the parties meet and there's an agreement for OCM to supply coal with interim arrangement. You recall that?
Yes, there was, as I said earlier, they agreed to continue supplying
Yes.
at 150.
And then,
So, I mean, they chose not to pursue arbitration, and instead they agreed to continue supplying at 150. We didn't have a problem with that, because we didn't have a problem with them. We had a problem with the price.
yes,
So 150 is willing buyer, as far as we were concerned. Because 150 is what was contracted. In fact,
Yes,
we
in
were
terms of the
obliged to
contract.
take the coal at 150.
150, 154, then
Oh,
Glencore-
154, yeah.
Yeah.
When you're talking thousands of tons, I mean, at 4 rand is
Then the termination of the cooperation agreement in June is followed by the letter of demand for penalties, Mr. Molefe,
Yes.
2015. The penalties for 2.17 billion rand.
the penalties for?
Penalties for 2.17 billion rand.
Yes,
Against
2.17.
OCM.
Yes.
Yes. Now, we have gone extensively, or at least to some extent, into that evidence in regard to how that penalty of 2.17 ultimately gets reduced into an amount of 255 million.
You talk about the settlement now with
The settlement item
Takeda.
with OCM. Chair.
OCM under Takeda.
OCM
Before.
under Tegeta.
Yeah, okay.
Who reduced it?
I'm asking you.
I think the question is, you remember that amount of penalties that was demanded from OCM when OCM was under Glencore, which was 2 billion rand.
2.17 billion.
Yes.
Yes.
When OCM was under Glencore, that claim of Eskom was settled at a much lower amount, namely 200 and something million
55.
rand. So the question is, do you remember that? And I think there'll be a follow-up question.
Yes.
Chairperson, the 2.17 billion had been outstanding since 2013, long before I arrived. The 2.17 billion was not a figment of my imagination. There is a person who came here, I just can't remember his name, who testified that he actually calculated the 2.17 billion. It was correct. And from wherever it was calculated in Eskom, it was brought to me as a legitimate claim that Eskom had. My job as the CEO was to ensure that money that is being owed to Eskom is collected. That is why I gave instructions that if needs be, we must issue summons before the matter prescribes, before the 2.17 billion prescribes. In fact, the 2.17 billion was accumulated, if I'm not wrong, while Mr. Ramaphosa was chairperson of OCM. So it was under his chairmanship that the 2.17 billion became due and not collected. Before I arrived at Eskom, there was no effort to collect the 2.17 billion. It's only when I was there that I said, but why are we not collecting what is due to us? And I even said, how can we go to Soweto and start collecting debt when we can't collect from OCM? Debt that was accumulated even when Mr. Ramaphosa was chairman. So that was the 2.17 billion. When I left Eskom in 2016, the 2.17 billion was still outstanding. Subsequent to my departure, I was not part of this, I was not there. I'm told the new owners, Tegeta, invoked the arbitration clause, and the matter went to arbitration. Guess who was leading Eskom's negotiating team during the arbitration? Ms. Suzanne Daniels.
Well, before you proceed, you have linked the failure by Eskom to claim this 2.17 billion rand based on penalties from OCM. You have linked it to Mr. Ramaphosa having been chairman of OCM. Are you making a connection?
No.
Are you suggesting he did anything to make sure it was not claimed, or what is the point?
It's just a coincidence, Chairperson, perhaps.
A coincidence, okay.
That while he
I
was,
just want to make sure we
that
know
while
what
he was
you're
chairperson,
yeah, okay.
the claim of 2.17 billion arose. And then there was an agreement. In my opinion, a dubious agreement, because like I said, I was questioning the authority of the person who signed the agreement. An agreement that I'm told had never served before the board prior to my arrival, prior to that meeting of April. Chairperson, perhaps maybe I'm being paranoid in linking all of these things up. But there was a 2.17 billion for which I was persecuted for trying to collect. Subsequent to that, after I had left, there is a hardship clause and arbitration that gets activated by the new owners. Perhaps even when Optimum had followed through on the arbitration, we might have ended at 200 million, like it actually ended up being. But I was not there when the 200 million was negotiated. I don't know if I had led the negotiations.
But had you left Eskom, or it's just that you were not part of the negotiations? But
I had left Eskom.
You had left
I
Eskom.
don't know, what year was it settled? 2017.
Yes.
I left Eskom December 2016.
Yeah, okay.
So when I left, what was due to Eskom was still 2.17 billion.
I understand you to be saying with regard to your instruction that Eskom's attorneys should demand payment from OCM of that 2.17 billion rand. I understand you to be saying you were told by people within Eskom that Eskom was owed 2.17 billion rand in penalties by OCM.
Yes.
And the people who told you are the people who would have made calculations
Yes.
as to how that amount.
Yes. And they
was
even
made
gave
up.
evidence here.
Yes.
And showed, I was watching, I didn't even understand the calculations. They had detailed
Yeah.
showing of how they calculated
Yes.
the 2.17 billion.
Yeah. So the point we are making is you understood the claim to be legitimate,
Yes.
and you understood your job as Chief Executive Officer of Eskom to be to make sure that that amount, that claim did not prescribe, and that you should recover whatever was owed to Eskom by
Yes.
OCM. But if somebody says that claim was not proper, the amount was not properly or correctly arrived at, you can't argue about that because you were not involved in how it was made up. Is that what you're saying?
I would say that as far as I'm concerned, it was correct because the primary energy people said it was correct. They even gave evidence here under oath to say that it was correct.
Yes, no,
I'm
but
not in a position to dispute that.
Yes, no, what I'm saying is to say it is correct, you rely on what they say.
What they said,
are,
yes.
Not that you could yourself work it out.
Yes, yes.
Yeah.
No, I was not
You
in a
were
position
not
to work out things.
to qualify to do that.
Yes.
Yeah, okay, Mr. Slater.
But also, Chairman, it gets even more interesting. Mr. Koko has laid a complaint with the public protector that there is 1.7 billion in penalties.
Did you say has or had sometime? Has recently.
I'm not sure where the complaint is now.
Yeah,
But he
okay.
has laid a complaint, as far as I know, he has laid a complaint with the public protector to say that there is 1.7 billion rand of penalties due by Optimum that prescribed and that were never collected from that period of 2012, 2015. There's another the 1.7 billion can never be recovered because it prescribed. And so he's asking the public protector to investigate who was responsible for collecting that debt and why didn't they collect it. I'm surprised it hasn't been his evidence here up to now, but that is what I was made to understand by him.